We're now here to turn to our next session, the heart of the matter, collaborating to improve permanency outcomes for youth. And as a reminder, if you're having any trouble seeing or hearing very well this session, for the volume, turn up the volume on your computer. And if you need any other assistance, check the help desk that's available to work with you on being able to access the session a little better. So the heart of the matter is shifting our focus to normalcy and the reasonable and prudent parent standard. And our goals today for this session are to identify some essential components to collaborating between state and tribal child welfare agencies and the courts on promoting permanency and normalcy and positive normalcy for youth in care. We are hoping to identify some overlapping responsibilities of courts and agencies, equip you all to be able to use some best practices in this area, and share some insight from our speakers today. And we're hoping to weave into this session a variety of perspectives. We'll hear state perspectives, tribal perspectives, court perspectives, and youth perspectives. And in order to do that, without further ado, I'd like to introduce our speakers who will be sharing their perspectives on collaboration to promote normalcy for youth in care. Judge John Romero serves as the Second Judicial District Court in the Second Judicial District Court in New Mexico, where he's the presiding judge of the Children's Court Division. The cases before him there include child welfare and delinquency matters, as well as adoptions. And in addition to his substantial court work, Judge Romero trains other judges and other stakeholders regularly through the National Council of Juvenile and Family Court Judges, and travels across the country, including here to DC. Just last year, he was here for the Trafficking Summit at the White House. We will also hear from Alicia McConnell, who is a young adult consultant with the Capacity Building Center for States, and who has spoken extensively on these issues. Alicia and her family were homeless for a number of years, and Alicia entered the foster care system and was in the system for several years before finding temporary permanence through a guardianship that subsequently ended. And Alicia actually petitioned and sought out to re-enter foster care. And we will hear more about her experiences throughout this session. I will note that now Alicia is back in care in the Portland area, where she hosts a radio show. And she volunteers with the Lakota Oyate Key Club, where she visits self-identified Native individuals who are in prison. She's involved with the Native American and Family Center, and in her spare time crosses the country to be here with us and to speak with stakeholders and others when she is able to. So thank you both for being here today.
Thank you.
I'm going to be asking questions of the speakers, but we also invite all participants and viewers to send in questions through the online platform. So if you have questions during the session based on anything you hear Judge Romero or Alicia saying, please send them in, and we will try to address them at the end of the session during the Q&A portion of our session. And I will be keeping an eye out for those questions that we can incorporate into, again, our Q&A discussion or at some other point later in our session. So thank you again, everyone, for joining us, and we hope you enjoy the heart of the matter. Judge Romero, we're going to start with you. Can you tell us how in New Mexico the Child Welfare Agency and court and anyone else began collaborating on normalcy issues in particular, and who was involved?
Sure. It's a great opportunity to be here today and share what we do in New Mexico and what I've also learned from the National Council of Juvenile and Family Court Judges about collaboration. I think one of the first and important points for my judicial colleagues is we have the opportunity to convene folks. We don't necessarily have to have the answers or even know what questions to ask, but getting together with other stakeholders and having a meeting, people are likely to come to that meeting and participate. That's not unlike what happened in New Mexico. Actually started before the Preventing Sex Trafficking and Strengthening Families Act was passed, but we were not really able to get together and talk about it until after the act was passed. And fortuitously, that happened coincident with the first National Judicial Institute on Domestic Child Sex Trafficking. After that was completed in November of 2014, we began a series of meetings, we being the Child Welfare Agency, the Children, Youth, and Families Department, Protective Services, and the courts, where stakeholders from the community and from the system were invited to participate. And there were some youth that attended those initial meetings, And then early in 2015, when the time was sneaking up on us and we needed to get moving on policies and procedures, the Children, Youth, and Families Department enlisted the participation of various youth groups throughout the state. And that resulted in initially monthly meetings with the youth participants, which were rather interesting. Part of the collaboration was that the youth drove the bus, for lack of a better term. They were asked when the meeting should take place because of their varied schedules, and they elected to meet after 3 o'clock in the afternoon on whatever the given day was. The youth had their individual internal meetings before each meeting, where they decided the agenda, the ground rules, and the systems folks, other adults, did not participate in those internal meetings. When the internal meetings ended, then the rest of the folks were invited in, and the youth led the meetings. They're the ones that decided how the agenda was going and spoke principally to the issue of normalcy, prudent parenting. There was some discussion about preventing sex trafficking, but most of the focus was on the normalcy aspect of the act. With regard to the preventing sex trafficking, the youth who did speak about that, or the meetings where that was a discussion, the takeaway was for anything that involves treatment of youth, you have to first develop a trust relationship with those youth. And it's got to be on their terms. You know, it's a slow process. It's not a 50-yard dash. And once that relationship is established, they're still the ones who should be determining what sort of treatment they're going to get, when they're going to be ready for it, and until and unless they're ready for it, treatment is not going to work. So that was a good takeaway from many of those meetings.
And you said that they were primarily, or perhaps most often, involved in discussions about normalcy. Was that the decision of the youth themselves that they were interested in that particular subject, or was that the intent of the other organizers and other stakeholders?
My understanding, it was the intent of the youth, because that was what was foremost in their minds, because the participants in those youth groups were youth who had completed, who had aged out of foster care, or some of whom were still in foster care as in the custody of the state. So that was an important issue for them to deal with in terms of what would have been better for me if I had had a voice in what was going on, what would I have chosen to do, what would be on my case plan, where would I have lived, what foster family would I have preferred.
Mm-hmm. And did that group end up having an impact on the policy that was, I assume, eventually drafted through this group?
The youth contributed to the development of the policy by speaking to it and having their voices heard, as described earlier. But the department, once they got to a place where they had a draft of the policy, the youth were reconvened, invited back to convene with the department and to give their feedback before public hearings were heard on a final product. So at the public meetings, many of the youth attended as well to not only ask questions, but to be able to provide answers for those in the public who wanted to know about specific parts of the policy. And even now, as things are wont to happen, revisions have to be made to the policy. And when that is taking place, the youth voices are invited back to address and to speak to the possible revisions that may be taking place.
And this policy, did it exclusively affect agency practice, or did it have some impact on court procedure or policy also?
It's important for judges to understand that any policy that your child welfare department comes up with, ultimately it affects your decision making. And it's important to be part of that process so that you know what the policies are in order to be able to work collaboratively in the court setting, not just with the department representatives, but the attorneys who represent parents and the attorneys who represent children, because New Mexico, I'm proud to say, has a culture of collaboration. And it's not always holding hands and singing Kumbaya together, but we try to get together and address the issues and decide what those issues are and to talk about them and come up with a solution. So that happens in the court process as well as in out of court. And in order for us to be able to know what's going on and what the policies are, judges need to be part of that process and to be able to ask the right questions in permanency hearings and interim hearings in our child welfare cases.
My next question was actually going to be, can you give some examples of the court's role, both in collaboration and in promoting normalcy for youth? And you've already identified a couple. One is convening a meeting for the stakeholders to come together to plan even or to explore collaboration. And asking the right questions sounds like another one. Do you have any other examples of how the court in particular can promote normalcy?
Sure. I think one of the important ways is ensuring that youth are in court for their hearings. And I know that that's onerous to some people. There are some folks, and Alicia will probably speak to that a little bit more later, but the notion by some of the adult caregivers is that court is not a place for kids. You shouldn't be there. That's a place for adults. But how can I, as a judge, get a child's input or even verification from them that their worker is meeting with them regularly, that the worker is addressing their concerns, and that their attorney is visiting with them regularly and representing either their wishes or their best interests, depending on how state structures are set up. So that's one of the discussions we've had. That's one of the collaborative meetings that we've had about youth and children in court and why that's important. And it's important that youth participate in the process. As many of us recall, for a while now, the mantra has been nothing about us without us, and yet in court, we talk a lot about children's future and what's going to happen to them without them being there, and that's not okay.
Right. And I think we're probably talking mostly about juvenile child welfare or dependency court. Is there any collaboration you've seen between the child welfare court and the delinquency or juvenile justice court?
There has to be, and there is, at least in my jurisdiction, because we know that they're all the same kids. They're all the same youth. Many of the juvenile justice kids started their court involvement by being wards of the state in dependency cases. The reverse is also true. Some of the young people, their first experience with court is because of a minor delinquency offense, and then somewhere down the road they get removed from their families, and they still have pending delinquency cases, but they are now also involved in the dependency court. And we've used the term a long time, either duly adjudicated kids or crossover kids, yet it seems like discussion among the various arms of the government that touch these families don't always speak about, they're not always on the same page. They're working at cross purposes. Happily in New Mexico, that's becoming less of a problem, and I think the protective services folks and the juvenile justice folks have created a culture that they actually speak to each other and collaborate on how to make things better for the family and the youth.
Great. What role would you say gender, trauma, and culture play in development of effective systems of care and services? So you spoke earlier about the importance of the voice of youth in talking about how to deliver services, particularly to survivors of sex trafficking. Do you have any other thoughts on how gender, trauma, and culture play a role in development of effective service delivery?
Certainly, and we heard earlier in the expo today about being trauma-informed, trauma-responsive, and I think we're making progress in that area, so it's not just a term that we use and don't understand, but that kind of dovetails into the culture piece of it as well. And New Mexico is not unique in representing multiple cultures in our population. But one of the areas that I think we are required to pay attention to, and not just that we should, but we're required to, is the Native American population, and pursuant to the Indian Child Welfare Act, and how we comply with the provisions of the Act. And now with the new regs upon us sometime in December, and the new BIA guidelines for state courts and agencies, it's important that the Native voice be heard and that the Native youth voice be heard in how we develop responses to their needs so that they are culturally responsive and not just what we think is right. Mm-hmm. The youth and the tribal folks are the experts in what works for them. And yet very often we impose what we think is best without asking them about what will work for them. So that collaboration on the cultural side is important. And the other aspect of youth that we see in both of our systems, child welfare and juvenile justice, is the LGBTQ community. And very vulnerable to sex trafficking. Boys obviously are trafficked as well, and they are in the system just like young ladies are. And we don't always understand or ask so that we can understand from the experts what will work for them.
And that brings up another point I wanted to ask about regarding collaboration. Whether you saw any or participated in any with child welfare agencies, tribal child welfare agencies, or tribal courts, or any other tribal groups within the broader collaboration you saw the court and the state agency engaged in?
For a long time now, New Mexico has very proudly been involved in the Tribal State Judicial Consortium, a gathering of tribal court judges and state court judges to address any number of issues that affect both systems. That is an ongoing collaboration and consortium, and much of the collaborating takes place there. And yet there are multiple issues that are addressed in the Tribal State Judicial Consortium. But in terms of delivery of services, how tribal courts can access state services, the memoranda of understanding that sometimes is developed between agencies and the tribal courts, and then a recognition that, at least in our state where we have multiple pueblos and tribes, that one size does not fit all. And more importantly, in order to have that collaboration, respect and an effort to understand others' systems, us understanding the tribal systems and respecting them, even though they may be different, is a challenge sometimes, because we want to, collectively want to think that our system is the one and only way, and hopefully that's fading into the sunset as well. But respecting other systems is very important in order to get collaboration going.
I'm interested also to hear your perspective on any challenges either to collaborating to promote normalcy and better permanency outcomes for youth, or for the court to be promoting normalcy. I mean, either in your court system or across the country, have you noted particular barriers or challenges to courts sort of increasing their promotion of normalcy? And if so, what recommendations do you have to address those challenges?
From the judicial perspective, judicial officers need to be aware of what the changes are in the law, and it's in order to be able to ask the questions at a regular court hearing about, well, your child in foster care, last time I remember, wanted to play football. Are they able to do that? Or they complained once about not being able to go to their friend's house and spend the night because they were in foster care. How is that changing now? What is being done to ask the question that any parent would? I want to meet your family. I want to meet, your friend, and I want to meet their family, and I want to know if they're going to be there. I mean, that's what we normally do with our children and grandchildren, as we make reasonable decisions about whether to allow certain activities. In the past, there hasn't really been that flexibility until this law was passed. But in order to know what's required, in order to be able to ask the right questions in court at hearings, we need to know what's being required of the agencies to ensure that we're all responding in a positive and an appropriate way.
So you'd recommend, again, collaborating with the agencies so you know what the new policies are, or how the law is being implemented on their end, and sort of what questions flow from that,
sure,
or what the youth could be expecting.
And there are a lot of great resources in this age of knowledge and technology. One of the great resources among many is the National Council of Juvenile and Family Court Judges. Their website has a lot of very useful material that's timely and on the money with what's taking place and the changes in the law, highlighting the law, what's required, not just of the agencies, but of judges, so we can hold true to the principle of being the inquiring magistrate. If we don't need to know the answer, but we need to know what questions to ask in order to ensure that the children and families that are in our system are being appropriately served, and that we're working toward a goal of permanency sooner rather than later.
Do you have any other points you want to make in forms of advice you would like to give either to courts or court personnel listening, or to child welfare agency staff about either collaboration with other entities, or about promoting normalcy more regularly for the youth in care?
My observation and heartfelt position is that we really are all working for the same goal of permanency and safety for children. We don't always agree on how to get there, but we really are a team. We're in this together, and it's not about us as an agency, or it's not about us as the court. It's about the youth and the families that we serve, and we should keep them foremost in our mind in anything we do. Secondly, Judges have great flexibility as to what to require within the bounds of the law, of course, to ensure that we're moving forward appropriately. Judges should not be hesitant, and I don't know too many that are, about saying things like, I need to know more about that. I'm not able to make a decision today or to make the findings you want me to make. We'll be back in 30 or 60 days to see if I know more so we can better serve the children and the families that are before us.
And is there any, do you have any tips for information that could be more regularly presented in your cases or in hearings before you to avoid having to prolong things, or does it vary on the type of request that's being made?
I think one of the things that is, again, a culture change is on the issue of reporting missing children, changing that culture so that we don't have to ask the question about what has been done to report this child as a missing child, and the child has been missing for a month. What reports have you submitted to law enforcement, to the National Center for Missing and Exploited Children, and have you filed those as part of the record? There are a number of publications that give guidance on how to form an order, how to create an order that you can modify to suit your jurisdiction. The National Center for Missing and Exploited Children, along with the National Council, has produced a technical assistance bulletin that contains tremendous and valuable information on that subject.
Great. Well, thank you. Well, Judge Romero, we will hear more from you later this session and ask some questions. And before I turn things over to Alicia, we'd like to ask a polling question and poll the group. And I think you will soon see a question being shared with the group about what is being done in American Indian or Alaskan Native communities to engage tribal leadership and tribal court officials in the development of a normalcy plan. And the options that you can see to choose between are: we have finalized a plan, we are developing materials to implement the plan, we have identified and or convened team members to work on a normalcy plan, we are gathering data and information to inform a plan, and we have not worked on this issue. And this question goes out to anyone observing, whether you are part of a tribal child welfare agency or court or another entity. We're interested in engaging what has been done with Native and whether American Indian or Alaskan Native communities so far that you're aware of to develop normalcy plans and to engage those entities with the work of the state agencies or individually. So look at all those selections again, and I think we will close the poll shortly. And then the results will come in that we will report out to you. And again, this is a question for anyone out there for what you know is being done or what you have heard about or what sort of activity you have participated in so far. And it looks like we had a number of responses, over half, about 56% of the people who responded saying they haven't worked on the issue, with the next split between individuals who are developing a plan or gathering data. As well as the nice 9% who has actually finalized a plan, and 6% who are working on who have identified or convened team members to work on a plan. So thank you all for participating. It's very interesting and useful to hear what's going on out there in the field right now. So we appreciate your input. And with that poll closed now, we will turn things over to Alicia. Alicia McConnell, you've heard a number of things, obviously, that Judge Romero was talking about. And I think one that he said early on talked about youth engagement in court. And I think a lot of people find it very important to engage the youth perspective in a way that makes youth feel comfortable and that they trust. But there is a perspective sometimes shared by judges or by others that say it's actually could be harmful to youth to appear in court during court hearings because the youth may be exposed to information that's very sensitive to them or might traumatize them even in some way. People are worried that the youth shouldn't see parents in a certain light or hear things about the parent in open court, since the court is not necessarily a trauma-informed setting or not one in which the youth's needs can be attended to in particular. At least that's what some people say. How would you respond to that?
From my perspective, in my opinion, I was first placed in foster care when I was 8 years old, and I never had the opportunity to participate in court or, go to them at all. Up until I was about 10, And I think that it would have been really beneficial if I had been given the opportunity to choose if I wanted to go or not. Not being given that opportunity, it was just a lot of stuff going on, and I feel like it would have been very helpful to know what was going on in my life, because these were things that were going to happen to me, and I think that it's really important for youth, to be able to have that choice.
And have you been able to attend more court hearings since you were 10? And we should note that you were in care for several years into your early teen years, and then you were out, and then you've been back in care for the past year or two.
Yes.
Okay. So have you been attending court more often since reentering care?
Since reentering care, I have been able to be more involved in my case, and it's still hard, to be able to schedule everything. But at least now I'm more aware of what's going on, and it's a lot more helpful that way.
So you found it valuable in some respects?
Yes.
Okay. And also, are people fairly open to you saying that you can't be in court, or that you don't want to be there for any reason?
Yeah, they're aware that, like, I'm busy now sometimes.
Great, thanks. Well, and we definitely want to hear some of your perspective on having been in care and being in care now, about how people you interacted with promoted your opportunities for normalcy and for engaging in opportunities that kids not in care had available to them, or that maybe made it harder for you to engage in sort of normalcy activities. Do you have any examples of situations in which you felt that your opportunities for normalcy were supported, or the reverse, and they weren't supported at all?
Well, I'm 18 now, and so the last foster placement that I had and my current one, they've been working really hard helping me get my license and go to school and hang out with friends. Sometimes when foster parents, when the youth wants to further, like, they want to drive, they don't want to have that liability or the responsibility for that youth, and because it's a whole other element to it. But I think it's important to remember that these youth are just like any other youth. They want to go out with their friends. They want to be able to participate and have a social life too. Yeah.
And then you said that that's happened. You've had more opportunities in these recent placements. Do you think that's in part a result of the people you've been placed with or that you're living with, or has there been kind of the culture shift that Judge Romero talked about, where it's a little more supportive across the board from the people you interact with at the agency or in court or somewhere else?
I think altogether it has been like a culture change. Everyone has been working like pretty collaboratively. Also, my placement that I've been in, they've been very supportive, and they're the best.
Good. Do you know, I mean, you've spoken about this with your peers, with other people, stakeholders like us and others. Have you heard of particular challenges other youth in care have faced in trying to engage in activities like Youth Not in Care? And if you have, so what are those challenges that you've heard about? And do you have any recommendations for how to address them?
I'm sorry,
Do you have in the other people you've talked with, or even in your own experience or with other youth, do you know about other challenges and barriers to sort of these normalcy activities that some other youth face?
Sure, yeah. Well, driving's the one that is like at the top of my list right now. Just knowing like other youth they're really trying to work to become more self-sufficient. Mm-hmm. Going to school, filling out FAFSA, going to college itself. And I think that it's important to remember to support the youth, whatever they want to do, even if there is an element of liability, like I said earlier. Yeah.
Great. In introducing you, I touched on some of the work you've been doing, which is a lot. You're very busy. And a lot of it is with Native communities. Did you feel supported in sort of that cultural connectivity while you've been in care, both now or earlier, in terms of making links to your tribe and the other opportunities for interaction with the Native community?
Yes, actually, my state and my tribe work very closely. When I was actually first placed in foster care, I was not enrolled. I'm currently an enrolled member of the Confederated Tribes of the Umatilla, sorry. So a little background, my dad was adopted out from California and was adopted into a family in Idaho, And by the time I was placed in foster care, I had already, I always identified as Native American. But the state worked for about a year and a half to go and unseal my dad's adoption documents. And the state worked really hard to connect me with my tribe. And they've been working together ever since. And now, after that, I was able to enroll in my tribe. And now I'm a member, and that's pretty cool.
That's great. So you were with, it sounds like you were working with the state child welfare agency, and you were in a state foster care placement.
Yes, that's correct.
But the state agency, whether it was your caseworker or somebody else, was working with, sounds like a lot of other entities to get you enrolled, to find out which tribe you might be a member of and get you enrolled?
Yeah.
And did you have, during your time in state, with the state child welfare agency, did you have contact with the tribal child welfare agency?
My tribe called into almost all of my court hearings. In fact, all of my court hearings. They've been very involved since I've been a member, which has been very helpful. And they even gave me like a brief opportunity to mentor another a fellow foster youth from my tribe. It didn't really work out, but it was really cool that I had that opportunity. And they're always trying to connect me with like urban powwows, things that I'm able to go to.
So you've been able to access kind of what you want or be part of it, of the activities you'd like to be a part of.
Yeah.
Why do you think you said the mentor relationship sounds like was a positive one for you, even though it didn't last very long, from what I understand for you. What do you think is the value? Why do you think it could be a positive thing for kids either in care or youth formerly in care to mentor other youth in care?
I think it's very important. Being in foster care is pretty hard. And it's nice to be able to look at someone and to be able to see someone who's made it, or is practicing normalcy and is becoming an adult and is doing okay, and is getting an apartment, and just becoming an adult and becoming self-sufficient. It gives you like a little like glimmer of hope. Like, even though I'm in foster care and even though this is really tough right now, like this person did it, and like it gives you something to look forward to. And I think that foster kids are experts on, they're the experts on foster care. Mm-hmm. And so if you give a youth an opportunity to go and, share their experience, share their story, and, give that little glimmer of hope to another foster kid, I think it's very helpful.
That's wonderful. I hope you have the opportunity to mentor other foster youth, or the many people who are watching right now, or in all your other speaking engagements. And I wonder, I know you had some time in care since you left care through a guardianship and then chose to reenter. Do you think, I'm wondering about if you had been able to participate in more activities, which you weren't, and actually it's not necessarily about care, but it was about your placement and your arrangement, and you weren't, as we have talked about earlier, afforded the opportunities to engage in a lot of activities that other kids were engaging with at the time. Do you think that would have helped with your situation then, either in placement or soon thereafter? And maybe you could have avoided some of the problems that you encountered in your mid-teen years?
It was really hard. So a little bit of background, I was in a very strict foster home that like I wore a uniform all the time, just to like give you like a little bit of an idea. But it was tough, and I think that it would have been really helpful during my teen years to be able to engage with other youth, especially foster youth or Native youth, which I wasn't really allowed to hang out with either. But I think that now that I have been given that opportunity, that I was able to re-enter myself into the foster care system and get a different home, and was able to find different parents, and was able to go to school and do my own thing. That was very beneficial, and it really helped me like expand. So even though I got a little bit of a late start on the whole normalcy aspect, it still turned out okay.
I should note, excuse me, that you did seek out the involvement of the court, right? Once you were in a guardianship arrangement that you didn't think was working out, you sought the court and came back into care.
Yes, that's correct.
Great. would you have any, as I asked Judge Romero, do you have any single piece of advice, either for kids currently in care or for the agencies or courts working with them, to promote normalcy more? I mean, to give these youth more opportunities to explore the opportunities available to kids who aren't in care? Or you can do one piece of advice or top 5 or anything like that.
Well, first and foremost, to people tuning in who are, working for state agencies, like we really appreciate everything you do, and it's a tough job, but somebody's got to do it, and I'm glad you're out there. And for youth, I think that just advocate for yourself, and remember, who you are, and stay true to yourself. As far as like promoting normalcy, just treat a youth as if they were yours, as if they were your own kids. We just wanna hang out with friends, learn how to drive too.
Great. And we're going to turn to questions either that you have of each other or that some of the viewers have written in to ask. But first, are there any other points either of you want to share about collaborating between, whether it's between the courts and the agencies or tribal or other communities, or just ways to, best practices for promoting normalcy for youth in care?
Making the courtroom itself, or the court experience, less traumatic is something to be mindful of. We're very blessed in my jurisdiction that our CASA program found it appropriate and found the resources to invest in a courthouse dog. So we have a black lab who, her name is Cassie, who's well known in the courthouse, and having her in the courtroom when children are in there not only puts the children at ease, but puts the rest of us gray-haired folks at ease as well, and it's a much friendlier environment. But also when you have children that are brought to court, as they're supposed to be brought, one of the things I'm trying to be mindful of is that they may have been told things that are scary about the judge. And I'm just another human being with kids and grandkids, but I have to make sure the kids are at ease. And one of the ways I do that is step off the bench before the hearing starts, take my robe off, and depending on how tall the little kid is, I may get down on my knee and try to be non-invasive, but let them take the lead on how they're going to greet me, or if at all, because some of the kids don't want to greet me, but let them drive the bus, not you as the judge. And it's surprising how they respond to that. They start talking to you about their new shoes and the fact that when they walk, the heels light up or whatever it is. And it's very neat to see kids in the courtroom. And we can be trauma responsive in court, and we should be. What does that look like in the court, and how should a judge respond to that? I think that depends on each individual case, and we judges can't know enough about what it means to be trauma responsive to not just the kids in our courtroom, but to the parents and the attorneys also.
Alicia, did you ever have a judge get off the bench and take off his or her robe and comment on your shoes, or vice versa?
No, but once my judge let me go behind her chambers and she gave me a lollipop, so that's like kind of close.
that is deep with you. Great. Is there any other advice you'd like to give to even judges in particular out there about either promoting normalcy or being more responsive to the needs of youth in care?
Oh, no. Great.
One very important principle, and you brought it up earlier, Lisa, that is, youth are the experts at what works for them. And we need, we give great deference to PhD types and doctors and, engineers as far as their expertise and their ability to testify as expert witnesses. We should give at least as much deference and credibility to youth about their situation and what works for them. They are the experts of their situation, and we should not forget that.
Thank you, Judge. I think we're now going to turn to some questions that are coming in from the audience. But if either of you have either answers to these questions or want to ask another of each other or add anything else, please do. Okay. Our first question is, at what age would you recommend that youth begin attending court hearings? And would you recommend that abused or neglected children or youth attend the hearings that involve them as well? So the first question is about the age of the youth, and I think the other is what types of hearings these youth should be part of. Would either of you like to answer?
Well, let me tackle that first, and then obviously you have a point of view on that as well. I don't think a kid can be too young to be in court. And it serves as a motivator for parents sometimes to see that 3 or 4 month old child that's been removed from their care, they're not very happy about it. You know, every one of us in the courtroom that has anything to do with the system is the enemy. So to have that child in the courtroom is a very, very special reminder to them of why we're there. And when a judge and the attorneys assure them that our hope and our plan is that this child can be reunified with you, that's what we're working for, that's the default permanency plan from the beginning. We're not against you, we're for you. Sometimes just seeing that child, which is the reason we're in court, is a good motivating factor for the parents. Now, there are certain situations where you have maybe older kids who may be re-traumatized by the experience of seeing a parent who was physically or even emotionally abusive to them. Sometimes those children are brought into the court before the hearing starts. They get to meet the judge, they see the stuffed animals we have, maybe Cassie's in the courtroom, and then they can leave. Their foster parents who bring them know these children better than I do, and they may, you know, they're usually given the freedom at your discretion, discreetly get up and leave the courtroom. You don't have to ask permission. Or if you know already that you want to not be around, you're free to leave. But thank you for being here.
And do you think, is that your recommendation the same even for younger children, if it's the earlier part of the case rather than a permanency hearing or review hearing later on, the part of the neglect or abuse adjudication? And in fact, you said that I believe it's in New Mexico is the policy or the law that all youth be at least given the opportunity to attend court hearings. Is that throughout the life of the case or just certain types of hearings?
Throughout the life of the case, but I think it's generally accepted that if we're going to have a full-blown trial at the adjudicatory hearing, that the gory details that come out of that and the volatility of it sometimes with respect to the parents' response, how the attorneys handle the case, that may be one of those hearings where the child is brought, gets to meet folks, and then leaves right away because they shouldn't be exposed to that. But at all of the initial judicial review, the permanency review hearings, again, depending on how the case is going and what the therapeutic relationship is between the child and the parents, that is a determiner, I think, of whether a child should come at all, or if they come, how long they should stay. Each case is unique and customized to the individual needs of the child or children.
And Alicia, do you have thoughts on the age of the children appearing in court or what types of hearings they come to?
I think everyone should always have the opportunity to be able to talk about and be there when they're talking about, you know, what's going to happen to you, no matter how old you are. And no, I mean, even if you are traumatized or you have had traumatic experiences as a youth, I think it's just as legitimate and just as important for them to be there. I mean, of course, like if, you know, there was a parent who was abusive and like, you know, you have to think about that, and like also just always give the youth the opportunity, and it's always their choice.
So ask them if they want to come, no matter what the age and no matter what the hearing. Great, thank you both. We have some other questions, and for Alicia in particular. What preparation would you have liked to have had prior to going to court?
So actually the first court hearing that I ever attended was the signing away of my parents' rights to a guardianship, and that was like the first time I ever went to court. And I really wasn't prepared, but what I would have liked, probably more time with my attorney. I didn't get a whole lot of that, and I feel like that would have been like a lot more helpful. Also, to show if I was able to show up earlier, and if there was a dog there, that'd be cool too. But you know, and also just like more talking, like this is what's gonna happen, this is what it's gonna look like. It was more like from my experience, it's like this is what's happening and this is what it's gonna look like. I didn't really get the whole this is what it's going to look like.
Right. Okay. And Judge Romero, do you have any suggestions for youth preparation also?
Certainly, and whether the child is going to be in the courtroom for the actual trial or not, they very likely know what's going on, something important. They may not understand the actual details of what's going to be taking place, but I've had occasions where the guardian ad litem and the CASA volunteer brought the child in like 3 or 4 days before the actual termination trial. This was a younger child, 5 or 6 years old, and they saw the courtroom. You know, I wasn't wearing a robe. It was a day we didn't have an afternoon. We didn't have anything going on in the courtroom. They got to, you know, roam the courtroom and the tables that the parents and the attorneys were going to be seated at, the table where the guardian ad litem was going to be seated at, where the judge sat, my court monitor and my bailiff were involved in the process. And lest we forget, they're very valuable resources as well, particularly, you know, court staff that also happen to be parents or grandparents. They're used to being around kids. And they're a calming source for these young people when they're in the courtroom. In one instance, the child never came back to court again, but at least knew what it looked like where the parents were going to be. As you indicated, coming in early before the hearing or coming in through the security entrance, you know, if you've coordinated that ahead of time with security so that they don't have to encounter parents or other family members who may be adverse to what's going on in the hallway where the rest of the population is, but to come in through the secure area and come into the judge's chambers and hang out in there. They're not really in the courtroom facing anybody, but some caring adult, a foster parent, the caseworker, someone can be in that other room with them while court is going on as well, so they don't feel totally left out.
And Alicia, have you experienced any more of that in your recent court appearances? I mean, you were saying that the first one, you weren't prepared and didn't really know what was going on. Since then, have you been able to get a better sense of what's going on in court before it happens, or are you just better able to understand the proceedings a little more now?
I'm much better able to understand. Also, the nature of my court hearings have changed. It's not so much, you know, about where are we going to put her? Where's the placement? It's more about like how are we going to maintain permanency, and so like as I've gotten older, it's changed. And it's not, you know, it's much more relaxed, and it's mostly just the judge checking in on me and, you know, make sure I'm okay.
Okay. Let's turn to another question. Judge Romero, did New Mexico experience any pushback on the APLA restrictions, either by attorneys or judges? And of course, what we're talking about is the limitation of the use of another planned permanent living arrangement as a permanency goal for youth 16 and over, as well as the other provisions of the recent PL 113-183.
The quickest answer to that is no, because not much has really changed. PPLA or APPLA, as far as what I experience in my courtroom, is usually based on what the youth wants, and even if that's the plan that's deemed after the initial permanency hearing, there's always the effort to ensure that the young person understands that adoption is an alternative. And now that guardianship may be an alternative, and give them a voice on whether you want to continue on a PPLA plan, or are you really maybe now changed your mind and you're interested in adoption? Because I think all of us can relate to the fact that at various stages in our lives we thought we had our mind made up about what we wanted to do, only to change it later. So not much has really changed. I think what needs to change is a specific finding in each hearing that ensures, and I viewed it as even more stringent than active efforts in ICWA cases, that there has to be even efforts above and beyond that to try to find appropriate family members that the child can be placed with, or an appropriate adoptive placement, and that the youth has a voice in making that decision. At least in my courtroom, I don't think we're being asked to make those findings, and I as a judge am guilty because I'm not asking for them, but that's part of what needs to change, and that may lead to pushback, but I don't think so.
Okay. And you have to ask the questions anyway.
Yes.
And that reminds me that Judge's point about revisiting adoption or other options as permanency goals or outcomes for youth reminds me of something, Alicia, that we talked about earlier when you transitioned sort of out of the guardianship or were considering coming back into care or other options. You indicated that your mind wasn't set throughout, and you kind of had needed some time and space to think. Can you talk a little bit about that?
Yeah, so the placement that I was in was great at first, but towards like the later ends of the year, it just became unsafe, and I just wasn't happy, and it just wasn't working out. And I wrote a letter to my judge and was like, "Hey, I don't really want to be here anymore. You know, can we talk about, you know, changing something?" And I got a lawyer, And the lawyer came over, and I was like, oh wait, I still really like these people, I love them, you know, I want to stay here. And that was okay. They were like, that's fine, you know, just let us know if you want to change your mind. And I did. And they were there, and they gave me that space, and it was totally okay that I changed my mind. And I actually was able to re-enter myself into the foster care system that way.
And first of all, we'll note that that's pretty remarkable that you reached out to the judge yourself, and then they followed up by assigning you an attorney, right? You said you got an attorney, but that was from the court assigning you one?
Yes.
But you were given some time and space to think things through about what you wanted to happen next.
Yeah, and it was no rush. It was, you know, on my terms completely, and I really appreciated having that space and that time.
Well, thanks for sharing that. We have another question about, can you comment on the racial disparities in the foster care system? Would either of you like to comment on that?
Disproportionality is an issue that we have to deal with in all of our court cases. And New Mexico is a minority-majority state, so with respect to Hispanic kids in foster care as opposed to the number in the population, it's my understanding from the data that I've had a chance to look at that racial disparities don't really exist there. But with Native American children, we're one of the states that does pretty good on that, but we can do better. If we're close to having disparities that are, you know, that exist in the foster care system, it's with Native American children. While they may represent a very small number of kids in out-of-home care, in terms of the population that they represent, it's very close to being disproportionate. But significantly, what I think is a problem that can be improved upon is having more qualified Native American foster homes, because it's not unusual that our Native American children in out-of-home care are not placed in accordance with the ICWA placement provisions, and the reason for it, that they asked us to make a finding as to that, is that there are no available, eligible Native foster families. And my overriding question on that is, why not? And I don't have an answer, so I shouldn't be asking the question, I suppose, other than say, why not? What can we do to improve that, and how can I be a part of that solution? So that's an area that I think we need to improve on in my state, and I would suggest in many other states where there clearly is a misrepresentation, a disproportionate number of Native youth in out-of-home care. Alaska being one of those states. My understanding is South Dakota, not much has changed in a number of jurisdictions from 38 years ago when the Indian Child Welfare Act was passed.
And you've spoken a lot about collaboration between the courts and agency and other stakeholders on normalcy and other PL 113, 183 provisions recently. Do you know of any collaborative efforts to address racial disparities or anything in that context?
Not specifically in the child welfare arena. As one of the model courts with the Annie Casey Juvenile Detention Alternatives Initiative, our county is very involved in looking at the racial and ethnic disparity issues, and it's a problem in New Mexico. And lest we forget about the rest of the data, you drill down a little further and you find out that the gender disparity is even more glaring, in that young girls in the juvenile justice system, the number of them is increasing rather than decreasing, where male referrals are decreasing, and not just in New Mexico, but across the nation. So what I said earlier about they're all the same kids, my suspicion, anecdotally, is that that may be mirrored somehow or another in the child welfare system as well. It's not just about racial and ethnic disparity, but we should be looking at gender disparities as well.
Alicia, is there anything you want to add before we move on?
Just piggybacking off of the need for more Native foster homes. It's especially important. There are only like 4 foster homes in my city, and I live in Portland, Oregon. You know, and there's just an overrepresentation of Native foster youth there. It's so important. As far as being Native American and being in the system, not only like are you dealing with the trauma itself of being in the system, but also from the Native perspective, the historical trauma that goes along with that. And not a lot of people can understand that. And I mean, only Natives can really feel that not a hole, but that trauma that's there. And so like, that's another thing why we need more Native foster parents.
Right. Okay. We have time for a quick comment by either of you before we close today. Is there anything else you'd like our viewers and participants to know, either about promoting normalcy among youth or anything else that you've talked about today?
We were talking earlier about the system, and we're all part of it. And I just want to acknowledge that the folks that I have the blessing of working with, we may have our disagreements, but I have to tell you that I have the greatest respect for the attorneys who work at very minimal attorney levels for the work that they do. Much of the work they do, they don't even get paid for. I have great respect for the agency folks who are in the trenches at 2:30 in the morning out investigating pretty drastic reports, for law enforcement, all of who are part of the system that we all are a part of. And we need to remember that we're a team. We're not lone rangers with each having our own agendas, but rather our agenda should be first and foremost the well-being and the safety of children and their families.
Thank you. Alicia?
I just, good job, all of you out there who are working really hard, to support our youth, and just thank you. It's a tough job, but I'm glad you're out there.
Great. Well, thank you very much to our presenters, Alicia McConnell and Judge John Romero. We're very glad that you are here with us today. We're going to wrap up, and as we exit this session, we encourage you to take a couple minutes to complete the evaluation first, to provide some feedback was most helpful to all of us here. And following this session and your completion of the evaluation, we'll have access to the exhibit hall. And we encourage you to stop by to hear from the Center for Courts, Center for States, and Center for Tribes. All of those entities will be at the exhibit booths during a concurrent chat session, which occurs right after this session, and we invite you all to be there. Also at our session, I believe, with the exhibit booth for the Center for Courts, our presenters will be there for a little while to respond to any follow-up questions or thoughts that you all would like to share with them. After that chat session and your time at the exhibit booths will be the next session, having the Normalcy conversation, policy and programs about developmentally appropriate services for children, youth, and young adults in foster care. That session will begin at 3:30 p.m. Eastern Time. Thank you all very much for participating, and thank you again, Alicia and Judge Romero.
Thank you.